Hi, I'm Steve Hansen. I'm a patent lawyer with Hansen IP Law. One thing that's come up a lot in my practice is I'll have a client who's upset or even incensed that one of their competitors got a patent on something that my client thinks was old, and they'll ask me, how the hell could the patent office issue a patent on something like this? And there's a number of reasons that can happen. I think the first thing to keep in mind is that you want to look at the claims of whatever the patent at issue is and make sure you know how broad they are. It could be that the competitor got the patent simply because they had very narrow patent claims that distinguish them from the prior art, and that those claims aren't really a problem because you could easily design around them and avoid them. So before you get too wound up, I think the first thing to look at is that. But there are situations where companies do get patents that seem relatively broad and seem like they should not have been granted. And legitimately, the question comes up, how could this happen? There's really a number of reasons for it. The first thing is that the patent office, during an examination process determining whether to issue a patent, they don't have access to all the types of information that can be used, for example, in a lawsuit to determine if a patent should have been issued. Typically, the patent examiners only have access to issued patents, published patent applications, and things like journal articles. What they won't have access to are commercial products that may have been on the market before the application for the patent of interest was filed. And so they can't really look at that kind of prior art to see if it would have rendered the claims unpatentable. The other thing is there are situations where a piece of prior art will not explicitly teach something that somebody put in a patent claim, and so the examiner may think that feature is new and issue the patent. However, if you did what was taught in the piece of prior art, you would have necessarily obtained that feature. It's called inherency. And for example, let's say you had a polymer, and no one's ever made this particular type of polymer to have a particular tensile strength. And so someone writes a patent claim that says, X kind of polymer with this tensile strength. The patent examiner thinks it's new and issues the patent. Well, it may turn out that if you look at the prior art, the older patents, they don't talk about the tensile strength, but if you do what they teach, if you follow directions for making the polymer, you would get a polymer with that tensile strength, and that's an inherent disclosure of that feature. The patent examiners don't have the resources to figure that out. It requires experimentation to do that. And so sometimes those types of features will get a patent allowed when they probably shouldn't have. Unfortunately, the patent examination process is not the place where that's going to get sorted out. The other thing is that there are certain requirements for patentability that patent examiners are not really in a good position to assess. A big one's enablement. In order to get a patent, you're supposed to teach someone skilled in the art how to make and use an invention. And there's a big multi-factor test for figuring out if a disclosure is enabling. And it really requires some complex analysis of the amount of experimentation that would be involved in going from the what's taught in the patent to obtaining what's in the claims. And then again, a patent examiner doesn't have the resources to assess that in many cases, unless it's pretty clear from the face of the patent document that they just haven't taught enough. So, these are some big reasons why patents that seem overly broad can be issued. Another one, though, is the fact that the patent examiners are not given an infinite amount of time to examine a patent application. The number that they used to talk about all the time was 19.5 hours per application. They may have changed a little bit. I think there may have been some changes depending on how complex the technology is. But either way, the point is that the patent examiner is given, a very finite amount of time for examining a patent application, and things will get missed when you are operating under those constraints. So, because of this, the Patent Office has some procedures internally that you can use after a patent's issued to invalidate it. A big one that's used a lot is called inter partes review, and that's where you can file a petition and you can challenge the patent's validity or the validity of some of the claims. There's another one called ex parte reexamination, where you basically submit some prior art and examiners will perform another examination if they think the prior art is compelling enough. And of course, ultimately, all the defenses that are available under the patent statute for invalidating a patent can be asserted in a patent infringement proceeding in court. and with expert witnesses who will go through some of these issues that a patent examiner is not really in a position to address during the examination process. So you got to keep in mind the process of granting a patent. It's more of a coarse filter for determining whether an invention is sufficiently new. And if it turns out someone wants to assert this patent, then people with more motivation to look into the validity of the patent will challenge it, through one of these proceedings, and may ultimately invalidate it. So that's how it happens that sometimes people get broad patents that seem way too broad relative to what you think they should have gotten. So if you have any questions about this, feel free to contact me. Otherwise, until next time, I'm Steve Hansen.